Trump travel boycott, tough inquiries in U.S. requests court hearing. A U.S. claims court has offered extreme conversation starters at those testing and protecting President Donald Trump's questionable travel boycott. The request restricted section for all evacuees and guests from 7 principally Muslim countries, until it was ended a week ago. The 3-judge board brought up issues over the breaking points on the president's energy and Mr. Trump's proof to connect the 7 nations to fear-mongering. Be that as it may, it additionally asked whether the measure could be viewed as against Muslim. A choice from the 9th U.S. Circuit Court of Appeals, in San Francisco, is normal in the not-so-distant future. Whatever it chooses, the case will most likely wind up in the Supreme Court. What did the two sides contend at the Interests Court? There was an hour of oral contentions from both sides on Tuesday. The Justice Department was first to put forth its defense, encouraging the interest judges to re-establish the prohibiting request. Legal advisor August Flinch said Congress had approved the president to control who can enter the nation. At the point when made a request to indicate confirmed that the 7 nations influenced Iran, Iraq, Libya, Somalia, Sudan, Syria and Yemen, he said various Somalis in the U.S. had been associated with the Al-Shabaab bunch. Be that as it may, at one point Mr. Flinch stated, "I don't know, I'm persuading the court." At that point a legal counselor speaking to Washington State told the court that tending the official request had not hurt the U.S. government. Specialist General Noah Purcell said the boycott had influenced a huge number of occupants of the state, with understudies postponed as they attempted to come to Washington and others kept from seeing family abroad. He likewise asked the court to serve as a mind official misuse. A Muslim boycott or not? The last minutes of the hearing were spent on whether the travel boycott added up to a close-out for Muslims, which would be illegal. Judge Richard Clifton asked both sides on the issue, bringing up it influenced just 15% of the world's Muslims. "I experience difficulty understanding why should construe religious hostility when in truth most by far of Muslims would not be influenced," he said. He likewise included that the sympathy toward fear-based oppression from those associated with radical Islamic groups is difficult to deny. A 15-page brief issued by the Justice Department on Monday night contended the official request was impartial as for religion. Be that as it may, in court on Tuesday, Mr. Purcell referred to Mr. Trump's battle proclamations about a Muslim boycott. He likewise indicated explanations made by one of the president's guides, Rudy Giuliani, who said he was made a request to think of a method for making a Muslim boycott work legitimately. Mr. Clifton likewise said the 7 nations incorporated into the boycott were distinguished by the Obama Organization and Congress as meriting visa confinements, in view of a dread risk. He asked, "Do you state that choice by the past organization and Congress as religiously persuaded?" "No," Mr. Purcell replied. However, President Trump had required an entire boycott, and in spite of the fact that this was not a total boycott, it was biased. What did the official request do? Its primary parts were nationals from Iraq, Syria, Iran, Libya, Somalia, Sudan and Yemen, even those with visas, restricted from entering the U.S. An impermanent restriction on all displaced person affirmations. The reprioritization of minority religion, deciphered to mean Christian, evacuee claims. A restriction on every single Syrian exile. A top on aggregate yearly evacuee admissions to the U.S. of 50,000. It came into drive on 27th of January and created some disarray at U.S. and outside airplane terminals since individuals were halted from loading up planes or kept from entering the U.S., and sent home. There was solid judgment and it was stopped last Friday by a government judge in Washington state. Therefore, individuals from the 7 nations with substantial visas could go to the U.S. once more. Washington state, Minnesota and different states need the Interests Court in San Francisco to allow the impermanent limiting request to remain as their claim works its way through the courts. Surveys propose that U.S. popular supposition is pointedly isolated on the issue.